Oh, it's going very well. We have a very large attendance. We have a very
Inovação e propriedade intelectual contribuem de maneira importante para uma economia circular mais responsável e sustentável. Essa tarefa é de todos nós, e para isso apostamos na ABPI. A gestão de Luiz Edgar Montauri Pimenta, à frente da ABPI nos últimos 4 anos, colocou nossa associação na linha de frente dessas transformações. E sócios de nosso escritório contribuíram em comissões importantes. Estamos vibrando com esse congresso, onde esses temas serão debatidos, e continuaremos nessa trilha, contribuindo sempre com a nossa ABPI. Contem conosco. Inovação e propriedade intelectual contribuem de maneira importante para uma economia circular mais responsável e sustentável. Essa tarefa é de todos nós e, para isso, apostamos na ABPI. A gestão de Luiz Edgar Montauri Pimenta à frente da ABPI nos últimos 4 anos colocou nossa associação na linha de frente dessas transformações. E sócios de nosso escritório contribuíram em comissões importantes. Estamos vibrando com esse congresso, onde esses temas serão debatidos, e continuaremos nessa trilha, contribuindo sempre com a nossa ABPI. Contem conosco. Inovação e propriedade intelectual contribuem de maneira importante para uma economia circular mais responsável e sustentável. Essa tarefa é de todos nós e, para isso, apostamos na ABPI. A gestão de Luiz Edgar Montauri Pimenta à frente da ABPI nos últimos 4 anos colocou nossa associação na linha de frente dessas transformações. E sócios de nosso escritório contribuíram em comissões importantes. Estamos vibrando com esse congresso, onde esses temas serão debatidos, e continuaremos nessa trilha, contribuindo sempre com a nossa ABPI. Contem conosco.
We are in the beginning of a mass extinction, and all you can talk about is money and fairy tales of eternal economic growth. How dare you!
a time that we can accelerate the circular economy. We really do believe it's now.
Bom dia a todos, sejam muito bem-vindos ao terceiro dia do
Good morning, everyone. Welcome to our third day, and yet another day for relevant topics for intellectual property. We are going to start with the plenary with Supreme Court Justice Barroso. Panels will start simultaneously as of 11 o'clock and can be accessed afterwards as they will be recorded. Before we start the plenary, I'd like to remind you our virtual coffee break. You can access on the orange button at this page. It's going to happen after plenary. We are going to start the first plenary, direct action of unconstitutionality, ADI 5529, and impacts of the Supreme Court decision, Supreme Court STF.
O Supremo Tribunal Federal entendeu que a garantia de 10 anos de vigência após a efetiva concessão de uma patente tornava indefinido o prazo pelo qual se poderia usufruir dos direitos exclusivos a ela associados. Entendeu também que isso tornava o parágrafo único do artigo 40 da Lei da Propriedade Industrial inconciliável com o ditame constitucional de provisoriedade dos privilégios que a lei deveria assegurar aos inventores, favorecendo interesses particulares em detrimento dos interesses coletivos. Ademais, na modulação da aplicação da decisão, optou por fazê-la valer a partir de sua publicação, mas excluiu esta limitação de efeitos simplificadores, as patentes de interesse para a saúde pública e todas aquelas que são objeto de ações que desde antes postulavam a redução de sua vigência, arguindo a inconstitucionalidade do parágrafo único do artigo 40. Em seu conjunto, decisão e modulação de efeitos corresponderam ao entendimento dos proponentes da ADI. Os argumentos apresentados sugerem que o interesse público não se coadunaria com a reparação pelo atraso na concessão das patentes na forma proposta pelo legislador, que teria por beneficiários apenas as empresas depositantes de patentes. Na opinião de outros, contudo, a decisão repercute negativamente sobre a avaliação das empresas quanto à robustez dos direitos de propriedade intelectual no Brasil. Apontam o ressurgimento recorrente da narrativa de que os direitos de propriedade intelectual atendam principalmente a interesses privados. Narrativa esta que não levaria em conta a própria razão de ser do sistema de propriedade intelectual, que seria o interesse coletivo em fomentar a inovação. Apontam-se receios também quanto à segurança jurídica da modulação adotada pela Corte Suprema, dado seu caráter discricionário, talvez contestável junto à OMC, em decorrência das exigências de equidade do Acordo TRIPS. Esta plenária discute esses fatos e possibilidades, que se tornam mais significativos por estarem associados à questão mais geral de qual seria a verdadeiro significado da função social da propriedade intelectual inscrita em nossa Constituição. Passo a palavra ao nosso moderador essa manhã, presidente da ABPI,
the floor to lawyer Luiz Henrique do Amaral and our moderator. Thank you so much, Erica. Welcome to our third plenary in this Congress. I'd like to start by thanking ABPI for the invitation for moderating this important panel and the participation of IPPI. I am chairman of BPI, and on behalf of ABPI, I thank you for the opportunity to be here. It is a complex debate with effects that are going to operate in the long term, definitely bringing some uncertainties and sensitive issues for the Senate. both IPPI and ABPI have positioned themselves as to the ADI against the sole paragraph of Article 40 of the Intellectual Property Act, tried to make the Supreme Court justices aware of the consequences of this provision. We refute the argument that the patent would get an extension because it does have 10 years. We also contested the argument that this would hinder the dissemination of knowledge. We believe it's the opposite. I think this would actually be favorable to investment and innovation. But unfortunately, by a majority vote, the Supreme Court understood it was unconstitutional. And this brings concerns. For many decades, Brazil has been challenged as to its real concern to a sound intellectual property system. And also the concerns in terms of the huge backlog. I started many years ago. I have sent to clients where patents were granted after expiration of its term. So we hope that this scenario is not back. We hope that the backlog is still a very big backlog. We hope that it is solved by the Brazilian PTO, and we don't have to revise all legislation given a further backlog for delays in Brazilian PTO examinations. Today, we have 3 relevant speakers who are going to go into detail about this topic, and for sure are going to bring various perspectives on this debate. We're going to start with Justice Barroso, then Luciano Team, a lawyer, and then Sergio Olivares from the Mexican PTO. This article is there to make sure that the terms are adequate so that patent holders enjoy the benefits of patents. We are going to start with Justice Barroso. Here in Brazil, we wouldn't even need to introduce him because he has a fantastic reputation. He's seen as very competent and have acted in the Supreme Court with great power of persuasion, with flawless perspective in his votes. Because we have a very large number of international participants that are following this session in English, I will very briefly describe your resume. Justice Barroso, in addition to being a Supreme Court justice, is a professor of constitutional law at the University of the State of Rio de Janeiro. He's also a professor at the University of Brazil. He has a degree in he has a Master of Law from Yale Law School, PhD in the University of the State of Rio de Janeiro, a number of postdoctorate studies at Harvard Law Schools, professor at Poitiers, France, and in Poland. He has academic experience in public law, including constitutional theory, among others, as well as constitutionality control, economic and administrative constitutional law. After this brief presentation, I give the floor to Honorable Justice Barroso. Go ahead.
Thank you very much. Good morning, Mr. Luiz Henrique Amaral. It is a great honor to participate at the 41st Congress on Intellectual Property here in Brazil, and to be accompanied by Sérgio Olivares, Professor Luciano Tim, so that together we can discuss intellectual property in Brazil, namely the recent decision issued by the Brazilian Supreme Court, STF, in the context of the direct action of Unconstitutionality 5529. My presentation will have three parts. First, I will draw an overview of the intellectual property in Brazil. Secondly, I'll be talking about the ascension of the judiciary in Brazil, the digitalization of life in Brazil, and then I'll specifically touch upon the ADI 5529. All over the world, we have the so-called Third Industrial Revolution. The first one took place in the 18th century through steam. The Second Industrial Revolution in the 19th century with electricity in the engine. And the Third Industrial Revolution, which is the technological revolution as of the second half of the 20th century. And the symbol is Internet, a connected world via computers and smartphones. Some people even say that we are on the verge of the fourth industrial revolution. Hence, we live in a world where the economy shifted. The main assets are no longer material assets. The main assets include innovation, technology, knowledge, industrial property. It is important to remember that we have introduced a new vocabulary in our life. Vocabulary that express utilities and actions we didn't have before and we can no longer live with. And I have a list of some of these expressions. They include Google. We could live without Google, WhatsApp, Uber, Dropbox, Skype, Facebook, Twitter, Instagram, Waze, Spotify, Amazon, iTunes, Netflix, YouTube, and for the single, Tinder. So we now live in this wonderful new land of information technology, biotechnology, nanotechnology, 3D printing, quantum computing, Internet of Things, autonomous vehicles, algorithms that become a very important concept. The most valuable companies, differently from the past when I was young, as well as my colleague, we were probably even more handsome, but the most valuable companies were the ones exploring oil, such as Exxon and Shell, the ones manufacturing vehicles, such as General Motors and Ford, and the companies manufacturing products, such as General Electric. None of them are amid the most valuable companies today that are actually Apple, Facebook, Google, and Microsoft. At least 5 of the most valuable companies presently. So that's the scenario where we have our discussion, which touches upon innovation, knowledge, a knowledge that becomes the main asset. And the main industrial asset is intellectual. And as I mentioned before, we are about to have new profound transformation that will change life enough, and they will even change what it means to be a human, maybe. In artificial intelligence that is closer every day with benefits and risks, as well as genetic engineering that brings promises of cure for diseases and conditions, but also with risks of life manipulation, the manipulation of the body, and the creation of Superman. And that's my introduction. We are in a new world, a quite new world where transformations take place at an exponential pace, and it is unforeseeable in the near future, unpredictable. And then I would like to talk about the role of the judiciary and higher courts in the world and in Brazil. After the Second World War, there is a trend, which is the emergence of the judiciary, which is valid worldwide. The emergence of the judiciary and a judicialization of life became very stronger in Brazil because we have a constitution that is very broad. In Brazil, the Brazilian constitution deals with the distribution of power and the preservation of fundamental rights as everywhere in the world, but our constitution always provides for the tax system, the welfare system, environment, family, children and youth, education, health, autochthonous population. So you have several subjects in our constitution, and this means uh, putting their discussion under the scope of the law instead of politics. Additionally, something that is especially important for our debate here is the fact that in addition to having a broad constitution that allows for a judicialization of life, here in Brazil, we can easily have access to the Brazilian Supreme Court, the STF. And that's because a list of organisms, entities, and people are entitled to ask the judiciary to act. So the governors, mayors, parliament, the Senate, commissions at the Senate, the general attorney, the chairman of the Bar Association, all confederations, and all trade union confederations. As a consequence, hundreds, thousands of entities might file actions directly at the Brazilian Supreme Court. So quite often here in Brazil, differently from other parts of the world, the Brazilian Supreme Court does not give the final word, but the initial word, or maybe the initial and the last one simultaneously, because many issues, many suits are directly filed at the STF before being discussed in lower courts. And the discussion and the debate that can take place in lower courts might be very fruitful, actually. And this is a brief overview of the Brazilian legal scenario with this quantitative judicialization of life with over 8 million lawsuits in progress. I would say that 1 in every 2 adults are now in court. So we have an overwhelmed system as well as a qualitative judicialization of life. So all matters that have importance reach the STF, whether through the extraordinary appeal or other types of appeal that can be filed at the STF. So we have a broad judicialization. However, this does not mean inactivism. The very fact that a matter, a subject can be discussed at the court does not mean that the STF should take an active role in extending the reach of our Constitution to subjects that haven't been provided for, which is the technical definition of activism. You know, there is a negative view of activism today, which means the undue exercise of the legal power. But I'm applying this expression in a technical manner, which would mean applying the Constitution to rules that are not provided for. In Brazil, we have a broad judicialization, but a quite moderate activism. Although, on my view, this was the case of a more proactive position. I can only talk about this case because it is over. I gave my vote, and my vote was not followed by the other justices. And I do think this was an example of judicialization and of a proactive exercise of the Brazilian Supreme Court that declared unconstitutional a provision that was in force for 25 years. So, one quarter of a century. So, in my view, this is atypical to declare a provision invalid, a provision that was in force for such a long time. It was a losing vote, but I hope I'm not speaking too fast because we have a colleague from Mexico. So I hope um, he's now speaking Spanish, very good Spanish, saying that he speaks Spanish a little bit as well, but he will be speaking Portuguese. And he will now discuss the direct action of unconstitutionality, ADI 5529, that discuss the Article 40 of the intellectual property law. According to the solo paragraph, the invention of a patent shall have a term of 20 years and a utility model patent a term of 15 years. According to the sole paragraph that I'll be reading for you now, because maybe you haven't watched it and followed the discussion, the solo paragraph is that was actually the object of the ADI sets forth. The term shall not be less than 10 years for patents of invention and 7 years for utility model patents, counted from the granting, except when the Brazilian PTO is prevented from proceeding with the examination as to the merit of the application due to a proven question pending or for reasons of force majeure. So the person who files the application for patent can have 10 years or 7 more years. And this was challenged by the general attorney, who was grounded on the violation on the temporality of patent protection, violation of isonomy, in other words, the equity between patent beneficiaries, violation of consumer rights, and violation of the freedom of competition. These were the main arguments, but there were also as well. The general attorney and actually Actually, what happened is that the union's legal advice was in favor of maintaining this paragraph, this provision, contrary to the general attorneys. And I will now give you some information that were provided for by the ABPI. First of all, the INPI's backlog amounted to 10 years and 6 months in 2016, one of the longest and greatest backlogs ever identified by the WIPO. On the top of that, INPI informs that between 2016 and 2020, it had been possible to reduce the backlog to 7 years and 9 months. However, INPI acknowledged there was a vast accumulation of applications. And finally, the INPI stated that according to the Action Plan 2021, it would be possible to reduce the backlog by 80% until December this year. Additionally, because there is COVID, a health and humanitarian crisis underway, the National Institute of Intellectual Property stated that in relation to COVID, there was only one medication that was officially indicated by sanitation agencies and the FDA, which is a medication called Redensivir. And there were 4 medications with a possible indication for COVID-19 that could be covered by the Article 40 that was being challenged. And finally, it was informed that there were 9 patents in force for over 9 years with a possible indication for COVID-19. So the impact was not devastating. When it comes to fighting against COVID, and of course, that could be specific exceptions. The prevailing decision, the decision that prevailed, has 2 grounds that I would like to highlight, because I think that they somehow are in the frontier of the concept of intellectual property protection. According to the prevailing vote, to the winning vote, it has been affirmed that the Article 40 sole paragraph triggers a higher expenses by the government when it comes to purchasing medication at a time where federal money should be saved in order to fight against the pandemic. Also, it has been stated that there shouldn't be given any priority to the individual interests of companies in relation to profit, to the detriment of the population that would be better served through the purchase of medication at a lower cost, as well as the availability of resources to fight against the COVID. Of course, I'm not going to be indelicate and criticize my colleagues. This was the winning vote. However, these grounds, these ideas, to my point of view, are in conflict with the very concept of intellectual property, which means having a patent privilege for a term that allows you to charge higher and in this way compensate for investment. And also the idea that the patent protection does not have the sole purpose of protecting the individual interest of the patent applicator, but also giving an incentive that is translated into investment for innovation, for the advancement for technology. So, given the prevailing opinion and the winning vote, I can talk about my vote. I was a losing vote, as well as Justice Luis Fux. Today, Mr. Luis Henrique Amaral said that I was able to influence some votes in the Supreme Court, and this was certainly not the case, because my point of view did not prevail. And I do believe that the pandemic scenario highly impacted the position taken by the justices. Although the INPI have provided information that showed this solo paragraph would have a minor impact actually on medication that could be used to fight against COVID in the pandemic. In my vote, I tried to highlight the importance of having an efficient registration process of patents that could encourage investment and innovation in scientific and technological research, because we're laying back in this area in Brazil, and it's very important to stimulate scientific and technological research in Brazil. The same thing as we did with education in Brazil, because it took us 100 years more than the other countries to make education universal in Brazil. We cannot do the same with in the investment in technology and innovation in Brazil. In a way, the scientific and technological research doesn't have an important visibility here in Brazil. Also, I mentioned that in my vote that patent protection before the final decision, this patent is not protected in a adequate and sufficient manner. And the article to say that is Article 44 of Intellectual Property Law, that says that the patentee is guaranteed the right to obtain compensation for the unauthorized exploitation of the subject matter of the patent, including exploitation that occurred between the date of the publication of the application and that of the granting of the patent. But see, this provision mentions the compensation, and this right can only be made valid in a retroactive manner after the final decision that acknowledges the authenticity of the patent. So in practice, in the real world, this is a highly complex compensation to obtain. And sometimes the company that made the undue exploitation no longer exists. And the Superior Court suggested it was possible to hamper the exploitation. And then I did a research, and I concluded that the states where this subject matter was under litigation did not agree with the unauthorization exploitation of the subject matter as giving rise to the right of the compensation. So this protection is quite fragile. The protection provided by Article 44 is actually rather fragile. Another aspect I tried to stress during my vote is the fact that actually the opposite understanding was actually assigning the inefficiency of the state system to the person who actually invested in the research for the innovation. So the 10 years and 6 months taken by the INPI to examine the patent application, a quite excessive and maybe absurd term, this actually undermines the private agent that was doing necessary research for innovation. And currently, the INPI has 312 staff and 308 pending job positions. In other words, there is a clear administrative inefficiency. And we should fill this gap without undermining the person who applies for a patent. Other countries have similar mechanisms of patent extensions with shorter terms than what we would have in Brazil. And the reason is because the backlog is not so important in those countries. It's not so great. You take United States, Canada, Japan, and even China, they will have an extension between 3 to 5 years because that's the period of their backlog. So it was equivalent. And because our backlog was much greater, we needed a proportionate extension. I do not agree that it would be against the Constitution because it would be temporary, 10 years after the final deposit, the final filing. And also, I do not agree it violates isonomy because the rule was actually going to be applied equitably. So for patents that were pending a decision for over 10 years. So this situation is not balanced if compared to the others. So I thought it was legitimate to give it a differentiated treatment. And then during my vote, I also stressed two points that I believe they should be discussed in Brazil, because there is a self-containment in the judiciary, I would say, and I've been writing about that actually. I think that the constitutional courts have two major roles. One is protecting fundamental rights and protecting democracy-related rights. When playing this role, it is natural and even necessary, I think, to have a Supreme Court taking a more proactive and expensive position. But for all the rest, I do believe the position should be of self-containment, because when the legislative power is omissive in relation to an important matter, in face of such an omission, I agree the Supreme Court can be more expensive to fill the gap, but in such a case, there was not an omission. There was a specific and express rule in force for over 25 years. So to me, I think the Supreme Court should not have an expensive position, should not act in an expensive manner. Because to declare a law inconstitutional, it has to be unquestionably unconstitutional, and I don't think that was the case. And secondly, the second point I think we should talk about, and a reason why I voted against it, is the fact that according to constitutional theory, you have institutional capacities. And in most countries, the Supreme Court can say the final word, can have a final say, but it does not mean the Supreme Court must have the final say, must interfere in all matters, especially when it comes to technical matters that require high expertise. And that's precisely the case of intellectual property, and whose subject was a provision that was already in force. So in my view, there was an institutional modesty, because I think we were not in place of assessing the systemic impact that could be the consequence of such a decision. And my grounds, my arguments haven't prevailed. And I approach at the end of my talk by reflecting on the impact of the decision. The first impact, and regardless of the material impact, is actually, I fear that we might have an impact on investment in technology and also an impact on investment in general in Brazil, because there might be a anti-entrepreneurship feeling around, a anti-entrepreneurial feeling, and this translates into a cost for Brazil, because once you declare a law in force for 25 years as unconstitutional and touching upon such a delicate matter with high amounts of resources involved, when you have this situation, you somehow give room to a type of insecurity and an uncertainty by investors. So this is not a material impact, this is not a financial impact, but it's a more abstract impact that in a way raises the risk perception in Brazil. As to the concrete effects, I believe that you, gentlemen, who work directly with intellectual property, you're going to be better positioned to assess the impacts in detail. I believe that based on the information that I received in the course of this action, should the information provided by the ABPI are correct, the impact might be lower because, you know, if they will actually reduce the backlog, which is now 7 years and 9 months, this is a high term. But it does not trigger the sole paragraph that states that there is a need of over 10 years of delay in order to give right to the extension. And they also promised to reduce by 80% the backlog. So I hope that there will be no impact in the future. You know, it's important to have hope. And in Brazil, it's even more important to have hope. As you know, the Brazilian Supreme Court modulated the temporal related effects. As a consequence, it is only valid for patent applications filed after the approval. And as you know, the Supreme Court made an exception for medication and health equipment. There was an article published by Folha de São Paulo newspaper written by journalist Marcel Teixeira. According to this article, we had the waiver of 3,556 patents, and more than 2,700 patents were preserved thanks to the temporal modulation provided for by the Brazilian Supreme Court. And the Brazilian General Attorney affirmed that at least 65 medications that had a high cost have been impacted by the decision. So these are, my dear friends, some ideas regarding intellectual property in general, and also regarding our decision. So I want to respect the time that was assigned to me. But we can see this judicialization of life in certain circumstances where it is not maybe justified, and also a certain activism by the state in economic areas. And I think this is happening in a more expensive manner than maybe we should. But thank you very much. It was a pleasure. Thank you.
Muito obrigado, ministro Barroso, pela sua
Thank you
apresentação.
very much, Justice Barroso, for your presentation and your comments that to a certain extent, us at ABPI believed if your contrary position had been open before the vote, it would have been very relevant because of your clarity and because of your impeccable logic behind your analysis. When we got access to your vote, we really could see the objectivity and the technical analysis and the flawless in your logic for voting. Often, these are talked about without looking at consequences. You have mentioned that this was a resource to add to the time. For example, if BRPTO takes 10 years and 6 months, the additional time would be only 6 months. So the 20-year lapse would have been finished. It would be just the remaining time that would be protected for the applicant. So there was this idea in the debate that the paragraph would make the term indefinite, and this would not be the case. And we also share your opinion in the sense that this matter was profusely debated in National Congress. Also, in the past, there was not such concern as to the backlog. In the past, when this paragraph was not there in the law, there was no concern on the part of the government or of the Brazilian PTO with the backlog. The concern came about because the paragraph was included in the law. So the paragraph contributed for an improvement of the public service. So it is now a stimulus for the Brazilian PTO to act more efficiently. Unfortunately, we're going backwards, and I agree with you. We hoping that the consequences are going to be limited. We hope that we're not going to be hindering investments that often result from innovation in Brazil, but not only foreign investments, but also national investments, because there are a number of researchers and institutions and Brazilian companies that applied for patents. And it's terrible because of this non-definition. The applicant cannot find investors because they don't feel confident to make investments without the opinion of the Brazilian PTO. Today, an investor who would like to invest in a new product, a new technology, a new plant, is not sure if there's still going to be an additional term after the exam by the Brazilian PTO. But we're not only talking about private investors. The development bank will have a problem with this, because will the development bank acknowledge the patent protection for granting an investment? But anyway, I am very grateful for your comments. As usual, it's contributed a lot for the debate on the topic. Most likely, we are going to have some kind of modulation, some kind of revision because of appeals that may be filed. We will be waiting for the publication of the final award, but the vote has been issued, and we hope that the consequences are going to be limited. Now, we give the floor to Luciano Tim, who's going to be speaking about this topic. I am going to make a brief introduction. Luciano is a professor of FGV Sao Paulo in economics and law, economic regulation law, economic law, and CIDES Sao Paulo. He's a partner at Carvalho Machado and Team Law Firm, postdoctorate in University of California, Berkeley, has a PhD in business law in the Federal University of Rio Grande do Sul, LLM in international law from the University of Warwick, British Council Fellow, Master from the Federal University of Rio Grande do Sul, and today is part of the CNDC, Consumer Protection Council. Without further ado, I'd like to give the floor to Council Luciano Tim. Well, good morning, everyone. I would like to greet very especially Justice Barroso, who has voted
de ambientes acadêmicos, né? E que tem, além da formação, de fato, grande frasista. Eu me lembro de algumas frases dele, por exemplo, nós que damos aula na universidade, né, o tema procura de um autor, né, e algumas regras práticas de palestras que eu também acabo aproveitando.
That
então,
I
obrigado por
tend
toda
to use,
a convivência acadêmica.
that I take the liberty to use.
Nem caberia a mim, mas o voto é magistral nesse tópico aqui.
Your voting was from a master.
Né?
I am a constitutional
Supremo, até porque,
lawyer.
Vendo de fora, né, como professor de Law and Economics, parece que quase está uma corte criminal, né, de tantos temas recorrentes na esfera criminal, às vezes 40 recursos,
court,
né,
very often,
enfim, quase
many appeals.
Delivery, né, vamos dizer assim.
It's nearly a delivery service.
Para alguns casos, mas
just for a number of
direito ao acesso à justiça.
Cases.
E saudar também aqui
I would also
ABPI,
like to greet ABPI,
Luiz,
represented by Luiz and Professor
Sergio.
My greetings to Mexico, he says in Spanish.
Em benefício do público,
I will not risk speaking Spanish like Justice Barroso did.
Cronômetro, né, para ficar dentro do tempo.
I am now going to
foi,
start my
previsto. E vou procurar, eu brinco que como professor de Law and Economics, se eu não ficar dentro do tempo, eu mereço ser demitido, né? Fiz uma alocação ineficiente do tempo. Aliás, ministro Barroso, sei também que o senhor é famoso na UERJ por trazer ao Supremo os melhores talentos, né? Inclusive,
at the Federal University for
específica de propriedade intelectual, né?
Greatest talents into the Supreme Court, which is the case of
caçador de talentos,
specialist, an expert in intellectual property that you brought over to the Supreme Court. So you are famous for your headhunting talents.
Desse julgamento do Supremo.
So we're going to be speaking about the consequences of the judgment on the ADI.
Vou recorrer à análise econômica do direito, que é uma teoria consequencialista.
Use the economic analysis
consequencialismo é a análise econômica do direito.
Based on consequence.
Na verdade, o consequencialismo ele é muito antigo,
consequentialism is nothing novel in Roman times and Greek philosophers
tomou muita força, né, o consequencialismo com a escola filosófica jurídica chamada de pragmatismo jurídico.
In the legal pragmatism
os americanos, que não é o pai da análise econômica do direito, né, mas é um autor bastante citado, foi
used by the United States.
Um importante livro sobre o que é o pragmatismo jurídico. Né,
about legal pragmatism.
Eu não sou um dogmático do direito, e o pragmatismo jurídico
legal
se
pragmatism
posiciona da seguinte modo: os fatos e consequências
as
importam.
facts and
mais do que
consequences
conceitos.
matter.
Eu terei
more
bons
than
resultados se mensurar
I will
as
have better
consequências
results
e se avaliá-las.
if I measure consequences
Mapas
and
da
if
gestão
I
dizem que quem
assess
não mede,
consequences.
não
If
gerencia.
you don't measure,
Tem desejo,
you
enfim.
don't manage.
Mas eu vou focar especificamente na análise econômica
But
do
I
direito para
will
fazer
be
isso.
focusing
A
on the
dificuldade
economic
que nós
analysis of
temos
law
é que quando a gente
for my
precisa lidar
argument.
com as consequências e precisa
What the
mensurar,
challenge
e a análise
is
econômica
when
do
you
direito
need
aposta
to
muito isso,
measure
nós precisamos
consequences,
usar dados e,
we
sobretudo,
need
estatística,
data,
né?
specifically
E isso, para isso a gente
statistical
precisa
data.
usar uma parte do cérebro, né?
So then we need
Aliás,
to use a
eu e o
section
ministro
of the
Barroso
brain,
compartilhamos matéria
and
de
I
doutorado
think
na UERJ,
myself
outro
and
juiz da UERJ
Justice
naval sobre
Barroso
esse tema, né?
shared
E o Eric me desafiou muito ali a estudar esses temas das neurociências e acabei picado por isso, né?
thesis
No
at
fundo,
the
o
Federal
grande problema é
University,
que
and I ended up
essa é uma parte do cérebro dita lenta,
focusing a lot on
faz
this
conta, que é pragmática,
perspective.
né? Que é o córtex pré-frontal dorsolateral, que muitas vezes não é acionado, né? A gente decide
part
muitas
of the
vezes,
brain
delibera
very
e debate
often
com base no sistema 1, que é o emocional intuitivo.
is not used. We use more
Curiosamente,
an
onde estão os dogmas
emotional
jurídicos.
part of
Acesso à
the
defesa, né? Às
brain
vezes você leva alguns dados e as pessoas
to take
seguem repetindo
decisions.
dogmas. Presunção de inocência, são dogmas
So,
jurídicos
very
importantes.
often you want data and
Função
people end up
social,
using
enfim,
dogma,
recorre-se muito
such
à
as
própria
a
política,
social
como
function and so on and so forth, and even in politics.
na obra do Iluminismo, né, o Pinker, a
Such
política é uma das coisas mais vitimadas pelo sistema 1, né, um debate muitas vezes aprisionado
Politics
por
is
uma falta de
very
racionalidade
influenced
de
by
dados, enfim.
the
E quando a
system
gente
one,
traz o
that is to
tema
say
da
the emotional
pandemia
system.
e
So
acesso à saúde
when
acaba
we
sendo
bring
muito,
the
no fundo,
pandemic into the
passível de um
equation,
debate não pragmático, de um
we
debate
end
muito
up
mais
carrying
intuitivo
out a
dogmático.
non-pragmatic debate
E,
and
no
end
fundo, a
up
gente não
having a
deveria
more
ver essa dicotomia
dogmatic
de direitos
debate,
sociais
and
versus
we should
individuais,
not
luto contra a
be
saúde.
looking into
O
a
Porter, que é um
dichotomy
professor
of
de Harvard, né, economista, que é o papa da gestão,
profit
da
versus
estratégia,
health.
mas ele escreve
Potter,
também sobre
who is a
desenvolvimento
professor
dos países, ele diz
at
que
Harvard,
um país
talks
se
about
desenvolver, ele
country
precisaria
development.
ter uma obsessão
He says
cultural com
that
produtividade.
the country should have an obsession with productivity,
produtividade,
and we don't have that.
E devemos romper, digamos
And
assim,
we should
uma ideia de que a sociedade é um
out
jogo
from
de
the
soma
idea
zero, que para alguém
that
ganhar outro
a
tem que perder, né?
society is a
Sociedades que
zero
prosperam
sum,
mais
that for one
não
to
tem essa
gain,
visão,
another has to lose.
de jogo
Most
de soma zero,
prosperous
né?
nations do not have
No
that
fundo, você pode
vision.
sim ter duas pessoas
At the end of the
melhorando,
day, you
que é a
can
chamada
have
ciência de
a
Pareto, mas
win-win
pode
situation
ter
where
situações assim.
two parties end up
Muito
gaining.
bem, porque quando você coloca coisa assim,
So,
A ou B,
when
né, acaba
you
que nós vamos muito
place
sistema
the
1 só a
debate
favor ou contra,
either
e
A
a
or
ideia
B,
é tentar mensurar
so
um pouquinho
you use
essa consequência dessa
emotion
decisão
to say it's either
do
or.
Supremo, e também do próprio PL 12, que trata sobre, digamos assim, vamos chamar a quebra, entre aspas, né, de patentes de vacinas relacionadas ao Covid.
Issue of patent violation as
Tem
to
algumas premissas
COVID-19
aqui importantes,
vaccines.
tá, pra gente avançar
There are
no tema.
some very important
Primeiro que,
assumptions to base our debate.
Propriedade intelectual, ela se volta
First
de
of
uma
all,
forma diferente, né? O
intellectual
objeto
property
bem incorpóreo é uma inovação.
has as an object as
E o que a gente sabe da análise
an
econômica do
innovation.
direito é que
And as we
a
know
certeza,
from
ou pelo
economic
menos a
analysis of
segurança,
law,
tem valor econômico.
certainty has
Um registro
an
de
economic
algo
value.
gera mais valor do que
Registrating
apenas
something
fato.
will generate more
E essa é a
value than
prova
a
disso
fact
é
in
que,
itself. And
se eu
to prove
vender
this
uma posse
is
no mercado
the
é um
example,
valor, se eu
if
vender a propriedade, a titularidade é
sell
outro valor. Isso vale até parabéns.
the use
Corpóreos.
of a property
Quem já trabalhou
is
com...
worth less
Porque fica
than
debate
actual
muito
ownership.
de saúde, mas, na verdade, a inovação é muito mais ampla e envolve tecnologia.
Innovation
E o Brasil
goes beyond
depende
the
muito
health
de inovação
related
tecnológica no agronegócio. É uma
issues.
das únicas áreas, talvez, que somos competitivos
Agribusiness
internacionalmente.
is a good
Embrapa gera
example. It's one of the few areas where we're highly competitive here in Brazil.
Para quem já trabalhou com
Embrapa is a very
tecnologia
good
sabe que,
example.
por
And
exemplo,
for those
startup
working
de
with technology
tecnologia,
knows
uma
that
coisa
technology
é o
startup is one
inovador
thing.
ter a patente,
One
outra
thing
é
is
não ter. Se for vender as
innovator to
cotas da
have
empresa dele sem
the
patente, é um
patents
valor muito mais
without a
baixo.
patent.
Acaba que, na prática, os
The
brasileiros precisam ir, as
shares
brasileiras
in
ir aos
his
Estados Unidos
company
registrar para vender, porque o
are
negócio, a cota da empresa,
it was
vale
worth
mais.
much less. Very often,
Esses
innovators
dias
go out to the
mesmo, por
United
exemplo,
States to
eu
register
gosto de
a
carro antigo,
patent.
então estava atrás de uma
I
Marta
like old
Rocha, né?
cars.
E no mercado
I
ela tem um
wanted
valor. Aí tinha um outro sujeito vendendo por duas vezes
Martha
aquele
Rocha.
valor.
And there was
Explicação
another
dele.
guy
Não,
selling
doutor,
for
é que,
twice as much. His
por que é o
explanation
dobro do
was,
preço?
what's
Porque
double the
tem registro
price?
no Detran.
Because we have a
Você tem
registration
registro, vale
at the
mais.
traffic department. If
Essa
you have
discussão, de fato, não
a
apareceu no Supremo. Como se
registration, it's
uma
worth more.
expectativa
This
tivesse o
discussion
mesmo
was
valor.
not dealt
E
with at
ex-post
the
a ser
Supreme Court.
confirmada pelo registro. Não tem. E também não tem, a gente sabe do ponto de vista de análise econômica do direito, do ponto de vista de estrutura de incentivos, na média, nenhum inventor vai querer ganhar tempo no NPI com algo que não vale menos do que o registro. Na média, o inventor quer é o registro, não ganhar tempo no NPI. Isso é falho do ponto de vista
to gain time, but they don't want to have an extension of the patent, they want the patent.
Que vai valer mais.
So, because their invention is going to be worth more.
Sobre inovação e desenvolvimento, para você inovar, você precisa do inventor,
if you want to innovate,
Pardal, e o cara que
you
coloca
want
dinheiro lá.
the inventor
Senão,
and somebody who's going to invest money in it. Otherwise,
é inexorável que para que a ideia vire de fato uma inovação, você
for an idea,
colocar isso no mercado, precisa de mecanismo de financiamento.
Something concrete, you need financial
outra
mechanisms.
Premissa é que a inovação,
another assumption is that
ela é um bem público.
Innovation is a
né? E esse bem público ele tem inerentemente uma falha de mercado.
And it has a market flaw inherently.
É aquele bem que você não consegue excluir as outras pessoas de utilizar.
Is something that you cannot exclude other people to use it. So if you have a concrete object such as a car, you can drive it, nobody else can drive it. And the way to fill the gap is by using intellectual property. If you protect it by intellectual property, you make sure that there's ownership to that innovation.
Algumas escolas, né, sobretudo a escola austríaca, mais libertárias, acham que propriedade intelectual é roubo. É curioso que os austríacos se aproximem dos marxistas.
Intellectual
protection, não dizer que era roubo, mas era um grande pecado, né? Às vezes aquele pessoal fica menos isso, menos juízes, menos quando vem propriedade intelectual, eles acabam tendo uma convergência, a meu juízo.
At the end of the day,
do direito, estamos equivocados.
People end up having a misguided position as to the intellectual property as a result.
É um bem que poderia ser utilizado,
would fill the
pode ser
gap
utilizado, eu não teria por que investir tempo, recursos nisso. Evidente que a gente pode discutir hoje se 20 anos é um tempo adequado, one size fits all, pode ser que seja muito, pode ser que seja pouco, acho que, como diria o ministro Barroso, é um tema para procura de um autor ou autores, o tempo ótimo. Possivelmente, em alguns casos, biotecnologia pode ser pouco, em outros casos, software pode ser muito, mas aí é um debate parlamentar, não é um debate baseado em evidência, não, rápido, assim.
Debate is not an evidence-based debate, always based on convictions or system one, the emotional system.
Você tem naturalmente um conflito entre países.
Obviously have a conflict
quando eu estudei na Inglaterra em 97,
when I studied in 97 in England, discussing TRIPS, there was a conflict between countries that innovate and have intellectual property and those countries that innovate less.
Mas não há dúvida que, do ponto de vista
But there's no doubt that from the theoretical point of view, intellectual property,
chamam sweat of the brow, né? O esforço pessoal,
sweat of the brow, that is the personal effort, investing in research and development. And as for an institutional design point of view, intellectual property is
racional do ponto de vista
rational.
De jogos, que você troca sociedade e inventor uma proteção e uma exclusividade de uso por um determinado período em troca da revelação, que vira
in exchange for the disclosure.
A gente sabe que
That
a
is to say
ciência
that it
evolui
becomes
em
public.
pequenos
We know
passos.
that science
E se eu
evolves
souber
in
o que outra
small
pessoa
steps.
fez, eu
And
consigo
if I
inovar mais
know
rapidamente
about
em cima.
what somebody else
Se
did,
não houver
I
essa
can
garantia,
maybe
o
innovate
incentivo pode ser de
faster.
não
If
tornar
there
público
is no
a
guarantee,
inovação.
the
E se mantém
incentive is
confidencialidade.
that innovation
É
is going to
famoso o
become
caso, né, da
secret.
Coca-Cola.
The
Nunca veio a
Coca-Cola
público.
case is very famous.
Coca-Cola, tudo bem,
It's never
não é necessário,
become
mas e se
public.
for algo
Well,
mais relevante como a cura para
Coca-Cola
alguma
is
enfermidade? Se a
not
gente pudesse inovar em cima.
essential. But what about if this was the case for very essential product?
Então, a gente tem que cuidar um pouco a estrutura de
So,
incentivos
we have
que
to
são
look after
gerados.
the incentive
Falando um pouco
structure.
do caso concreto aqui,
Talking about the
primeiro,
case at
a gente
hand,
pode ter uma discussão,
first
não
of
é o
all, we
caso aqui,
can
né, do que é
debate, which is
necessário
not the
para
case here.
inovar. O
What
professor
is
Cotter
needed for
fala muito isso no
innovating?
livro O Nó de Salomão.
No, the Solomon book author
Você precisa de ideias. E o que o professor
mentions-
Cotter diz, e eu concordo, é que
Professor
existem
Cotter says
ideias
you
boas
need
e ruins.
ideas. There are
No
good ideas
Brasil
and
tem
bad
muitas
ideas.
ideias ruins que circulam.
Brazil has many bad ideas
A
going around.
Acemoglu diz que, por vezes, muitas vezes o governo erra de propósito. Eu
Very
acho que não, às
often,
vezes tem
the
ideias
government
ruins, né? Tem, às vezes erra de
makes
propósito.
mistakes
Ideias
on
ruins.
purpose.
Mas você
No,
precisa
I
de
don't think
boas
so. I think
ideias
it's bad ideas. You need good ideas.
e você, para ter boas
Actually,
ideias, é evidente que
and
você
for
vai
you to
precisar
have
de
good
educação
ideas,
de qualidade,
obviously, you have to have good
básica e
education,
universitária.
both
E nisso
primary
o
and
Brasil
secondary, as well as higher
vai mal,
education.
basta ver os
Brazil has
resultados
terrible
de PISA, enfim.
track
E
record.
vejam, e aí só
in this
talvez
area.
aqui, ministro Barroso, não diria uma
And
discordância, mas
Justice
o Brasil
Barroso,
gasta
here
mais
is my
do que a
only
média dos países. Não
disagreement.
estou defendendo,
Brazil
estou no
spends
dado, né?
more.
Estou no sistema 1 lá. O Brasil gasta mais do
Spends
que a
more
média dos países do OCDE em
than the
educação.
average
Sinal
of
que,
OECD
Porter
countries
tem razão, nos
in
falta alguma
education.
obsessão com
Potter is
produtividade.
right.
Talvez
We
estejamos
need
gastando
the
mal.
productivity
Talvez façamos a
obsession. We're
destinação
spending terribly
desses
our
recursos
money.
muito para a universidade,
The
pouco para o ensino básico, aí já é uma outra
resources
discussão,
are
né?
going to higher
Vejam que
education
curioso, a última
instead
vez
of
que eu examinei
primary
os
or
dados,
secondary education.
para minha surpresa, o Brasil, em citações, ele é responsável por 2%
Brazil
da
is
ciência mundial. Está
responsible
diminuindo,
for
porque de fato está diminuindo.
2% of
Mas o
global
Brasil só
science.
gera
This was in the past.
0,2% das
Actually,
patentes. A gente não tem
0.2%
aplicabilidade
of
na média na
patents.
nossa
We
pesquisa
don't
universitária.
have
Eu brinco que a
much.
gente era bom de paper e ruim de inovação.
We're very good at papers, but very bad at innovation.
Porque a
I
patente,
usually
né, é
joke.
uma ideia que eu preciso ter aplicabilidade,
Patent is something
inclusive
that has to
econômica.
be applicable and
Vejam,
it has to be
Para
economically
isso, você precisa
applicable.
possivelmente ter uma
So, in
estrutura
this
de
sense, you
incentivos de
need to have
remunerar os
some
pesquisadores das
kind
universidades
of
públicas, né? Não só com
incentive
bolsa
to
que ele vai ter que
compensate
publicar o paper, mas ele tem
researchers
que ter uma
for
parte,
government
um
universities.
percentual da patente
They
que ele
need
gera,
to
vai em outros países.
publicize papers.
Aqui
They
tem muito
have
preconceito,
to
aqui
have.
tem inclusive preconceito de
There's so
cooperação
much
entre a universidade
prejudice
pública, que gera mais ciência na média, e setor privado,
between
que
partnerships
trará,
between the
digamos
government
assim, as demandas a serem
universities
resolvidas
and the private
pela
sector.
academia. Não por acaso a vacina se chama, né,
So,
AstraZeneca Oxford. Possivelmente, eu não conheço esses
AstraZeneca
detalhes,
Oxford
possivelmente é
vaccine
fruto
is
de
not a
uma colaboração,
coincidence. It is
né?
the result of
Esse
a
caso
partnership,
da
obviously.
vacina do Covid,
So,
inclusive, é um excelente
the
caso para a
COVID-19
gente estudar,
vaccine
para ver
is
como a
an
decisão
excellent
do
case
Supremo, a
for
meu
us
juízo,
to
vai
look
ser
at
inócua para aquilo que ela queria se
prove
destinar.
that the Supreme Court
Não vai gerar
decision is not going to be effective
Porque não foi
in
pelo
its purpose. It's not going to
que nós
generate
não temos
innovation.
uma
It's not
patente
because of the sole
de
paragraph,
vacina
Article
para o
40,
Covid.
that we don't have a patent
Índia
for
tem,
COVID-19. India has it.
Rússia tem, China
Russia
tem,
has it.
Estados
China
Unidos tem
has it.
patente
The
para
United
Covid.
States
E
has
vejam como
COVID-19 vaccine patents.
esses dilemas do mundo novo que o
In
ministro
addition
falou,
to the debate
também
of
tem
the
essa
Brave New
mudança,
World
né,
mentioned
do
by
Oriente.
Justice
porque vejam, a
Barroso.
Europa continental não conseguiu desenvolver uma vacina.
Continental Europe did not manage to develop a vaccine.
Então vivemos momentos curiosos.
Asia did.
O fato é que
So these
me
are
parece que
interesting
a
times.
consequência, seja do projeto
So
de lei,
it seems
seja
to me that the consequence
seja
of the
da
bill
própria decisão do Supremo, com,
or
digamos
the Supreme
assim,
Court
eu assisti inclusive a
award,
sessão, né, muitos argumentos mais retóricos, quase de política pública, né, e não tanto assim, eu esperaria, né, na Suprema
around
Corte,
government policies. I would
mais de alguns
expect
pontos dogmáticos, né,
a
more
dogmatic
literatura jurídica sobre isso.
Position on the Supreme
Mas a tendência
Court.
é que, no fundo,
had been in effect
sinal.
for 30 years.
Não é o fim do mundo,
So
né?
there's
Tudo
a
vai
lot
parar,
of literature around
mas
it.
do ponto de vista de
Well, it's not going to be the end of the world, but as
esperado,
for
eu
incentive
não diria
structure,
que seja
expected
uma
incentive
decisão
structure,
que
I
venha a
wouldn't say
produzir
that this
os
decision
desejos
is
que
going to
ela
produce the
enuncia.
effects as
Será que ela vai fazer com que empresas venham pesquisar mais no Brasil? Será que ela fará com que a indústria nacional se desenvolva? O meu mestrado foi sobre a proteção da indústria nacional na década de 80. O que aconteceu? Nada. O que seria esperado de proteger a indústria nacional, né? A proteção da indústria de tecnologia brasileira me fez usar computadores, como eu não era de família, digamos, abastada, né? Estudei em colégio público, uma boa parte da minha vida. Aprendi computadores, aprendi computação no famoso TK-85 e TK-2000, né? Foi o que a indústria brasileira conseguiu gerar sem concorrência e com subsídios.
The Brazilian industry managed to generate with subsidies and without competition. I am very skeptical.
A proteção da indústria nacional. Tentamos isso de novo.
National industry protection, protectionism. Let's not forget that in 2014, at the time, we lost 7% of our GDP.
Então, não acredito que, per se, nós venhamos a desenvolver inovações. E, de novo, a gente tem que pensar não só em saúde, que eu entendo que o tema seja sensível. Eu até entendo que o Congresso quisesse mudar, que isso está gastando muito.
The universal health system, SUS in Brazil is spending a lot of money.
Do ponto de vista até dogmático, quando converso com os funcionalistas, essa decisão, assim, um setor econômico é uma regra, uns outros setores econômicos uma outra regra, né? Parece uma lei, né? Então, acredito que não tenda a produzir os efeitos, e tudo, no fundo, começa com um estudo, ao que se tem notícia do julgamento supremo, de um estudo do Tribunal de Contas da União, que dá conta de que, de fato, a União gasta mais por conta, gastaria por conta deste prazo adicional que acaba acontecendo em razão da ineficiência do INPI. Parece mais eficiente, mais de acordo com a ideia do Porter, né, com essa obsessividade por produtividade, que melhorar. Decretar a inconstitucionalidade de uma lei de 30 anos para resolver o problema do INPI.
Well, then they came with a very easy solution. Just decreeing the unconstitutionality of a rule that has been in effect for over 20 years.
Mereceria talvez um encaminhamento ali no locus, né? No fundo, não fizemos aquilo que o 20 da lei de introdução,
we didn't do
a lei de segurança jurídica, o próprio Supremo
what was intended.
Né? Poderíamos ter pensado por um interessante caso de mensuração de efeitos, né? Então,
measuring the consequences.
Que, no fundo, o que seria esperado,
I think, at the end of the day, what would be expected, that we're not going to solve the innovation problem.
Mandamos uma mensagem ruim,
we're sending a terrible signal, although not final, well, not the end of the world.
Mas realmente
we shouldn't really paint the apocalypse, but I don't see any elements to hope that
não, acho que
They prioritize public interest in detriment of profit. I'm soon wrapping up. A number of international companies are selling the vaccine at cost price. Where's the profit there?
Uma discussão de pessoal da área técnica, não é o fato de você licenciar a patente ou quebrar que vai resolver o problema, porque você precisa o IFA,
This is not going to solve the problem. You need
no fundo, parece muito mais
the input to manufacture the vaccination.
Como é que fica o sinal, né? O que dizem os especialistas é que essa é a primeira de muitas pandemias.
Say this is the first of a string of pandemics.
Tanto vindo do Congresso quanto o que é esperado dessa decisão, com todo o respeito, mas eu não acho que ela vai produzir os bons desejos.
I don't believe that decision is going to meet the purposes announced.
So agradecendo mais uma vez o gentil convite da BPI, que está ao lado de tão
speaker, and I'd like to thank once more ABPI for the invitation to be sharing this panel with such respectable peers. Thank you.
Muito obrigado, professor Luciano, pela sua...
Thank you ever so much, Professor Tim, for your considerations. Unquestionably, we have times of uncertainties. It's difficult to measure the effects and impacts. And when it comes to discussing health and the pandemic, the effects of the decision become broader as they reach all economic segments, being totally pervasive in a way, and it can impact patent in very different areas. And you mentioned the biotechnology in agriculture. Brazil is a pioneer in this area. We've developed patents in Brazil by Brazilian institutions for varieties that combine biotechnology and this segment actually should benefit from extra attention from our government, because this segment is very dynamic in the Brazilian economy, so it deserves more incentives and attention. Justice Barroso will have to leave the session, and I would like to apologize for Mr. Olivares, because before giving him the floor, I will make a few comments to Justice Barroso, because I would like to have his opinion now, because, you know, Justice, the discussion was very much limited to the pandemic and to health. However, when the Supreme debated the case, I haven't heard so much about this cross-cutting feature of patents. During the modulation, of course, exceptions have been given to health, but the decision is actually cross-sectional because it is applied to all segments. So if you could please make a few considerations about that before you leave the session. Thank you so much, Luiz Henrique, and apologies for Mr. Olivares, because this session was supposed to end at 10:30 and I have another meeting at 10:40. So I apologize. Mr. Amaral, you know, I actually think that we are before an administrative issue, not really a judicial one. As I said in my presentation, in Brazil, we judicialize certain matters because we have certain matters discussed under the scope of the judiciary, but they could be discussed elsewhere, I think. For this matter, for this issue, we have a diagnosis. We have an autarky that has the mission of addressing the patent issue, but it does not have the necessary resources. So we don't need a decree to solve it. We need an administrative decision to open up job positions, to hire people, to provide the institution with discuss the judicialization of health, but don't discuss the health budget. In a way, we are transferring the discussion to a place where it was not supposed to take place. You should be discussing about that when the budget is being approved, and then you can discuss other issues in other spheres. But the judiciary can maybe save one life accepting granting authorization for a procedure or for a medication, but it's impossible for us to cover everything. So certain issues shouldn't be resolved in the judiciary. And the problem that we have here is the fact that we have an autarky that has the mission of granting patents, and most of its job positions are vacant. So it is an organism that is, of course, inefficient. So it requires administrative action, or maybe also maybe the private sector, important industrial and intellectual property law firms could set up strategies and could contribute with material means. When I was supervising the elections last year, we were in the middle of the pandemic and we had no budget for the purchase of 9 million masks that were necessary for people at the voting bureau, and other and sanitizers and other equipment. So I did a call within the private sector. 40 companies sent their bids, and we were able to secure equipment and protection equipment all over the country for the conduction of the elections. So I do believe that the budget bottlenecks and administrative difficulties can be solved by the private sector. Do I think this is ideal? No, of course it is a trigger. However, it's better to have it than not having anything. So I would seriously take into consideration the possibility of having an effort made by the private initiative to actually indicate a diagnosis for this problem, because we need to have a correct diagnosis. Once we have the diagnosis, we need to know whether the public power is able to fill the gap. Brazil is a relatively young democracy. We are a country with lots of deficiencies. So the public power need to make choices that might be tragic when it comes to resource allocation. And Luciano, Professor Tim knows a lot about that, about this tragic choices made by the public power. So unless we have choices made by the government that can help the INPI, it is up to the private sector maybe to do something. I'm not transferring the problem to the private sector, but life is made of incentives and disincentives. So if this is of the interest of the private sector, maybe the private sector can look for the necessary incentives. The problem is actually to have 10 years in average to have the approval of a proceeding. So the judiciary is competent to issue an opinion judicially, because we have the final say, but the judiciary is maybe not the best sphere to make decisions about it because we don't really understand it, actually. We haven't been prepared this way. So my vote was not saying that this was good or this was not good. My vote was in line with the thinking that it is not incumbent upon us to take a position. So I think that the judiciary, to reply to your question, is not in charge of solving it. It is an issue pertaining to the administrative branch, and that can have the help of the private sector. You know, after years of therapy and analysis, we learned that sometimes the fault is of the others. And I think we should find ways in the public administration or in the private sector. And I do not believe the judiciary is the way to solve the issue. Justice, it's so important to hear you saying it because we have actually a proposal in this sense. We are thinking about it because the INPI is a superavit organism. We collect fees that are actually way above the necessary, and these fees are allocated to the national treasury that allocates part of it to the budget. So the INP actually does not have financial independency. The resources exist. However, the institute is not able to make use of it. So we at the INTTI are struggling to obtain the financial independence of the INPI because the resources the INPI would have the right to would be necessary to hire new positions, would be enough to train the current staff. So we could actually fill this gap. And we have PhDs, we have lots of people with high expertise at the institution, and we could make great use of them, greater use of them. We need qualified, skilled people to carry out this work. But unfortunately, INPI does not have the financial independency now. You know, Mr. Amaral, I'm no longer a lawyer, and I miss it actually. But the Department of Penitentiary Crimes was able to secure their resources. They didn't have this independence, but they had, but the branch was able to receive the authorization to allocate its own resources. So maybe this is a background that can be of your interest. So I would take this debate into consideration because this could be taken actually to the public debate. The tax is a fee that is related to a purpose. So this is a debate that we could have to discuss the destination of the resources. And I'm so sorry for having interrupted you. The budget issue concerns me greatly because you might end up asphyxiating an organization.
Acho que o Luiz Henrique caiu, ou fui eu que caí?
Não, acho que foi ele.
Foi ele, né?
Foi.
Infelizmente, o nosso moderador está com a internet.
Unfortunately, our moderator has a problem with his internet connection. So before he takes the floor again, if the justice wants to make some final comments. Oh, I think he's back. He doesn't have his mic on, but yes, here I am. Can you hear me? We are gonna certainly be taking your suggestion into consideration. Thank you very much, Justice. I know that you have to go, but thank you very much for your participation. So now I'm gonna switch to English so that I can better communicate with my friend and colleague, Mr. Olivares.
Sergio, thank you very much for joining us today. Sergio Olivares is an attorney well-known and well-reputed around the world. It's a leading IP attorney in Mexico, and he has an international reach in his reputation and his activities. So it's a great pleasure to be able to have you here today, Sergio. I'm just going to go on a brief presentation for all our participants to know exactly you better from the professional side. Mr. Olivares has a very broad experience in extensive areas of IP. He's skilled in the prosecution and litigation of intellectual property rights, including trademarks, copyrights, patents, and unfair competition. He is proficient across all areas of intellectual property law, but works mostly closely with the firm's patent group. Mr. Olivares is highly recommended by leading industry publications and directories as a leader in IP. He's been very influential in the Olivares law firm in supporting the firm's efforts to add new areas of practice and industry groups. Mr. Olivares has played a key role in the establishment of many of these new groups, including regulatory and administrative law groups, life science and pharmaceutical group, and information technology industry group. After his graduate, Mr. Olivares has trained with two prominent IP law firms in New York City, Morgan and Finnegan, and Canyon before joining Olivares. He will be addressing us from the perspective of the Mexican law on the issue of a possible extension of terms of patents. And it's interesting to have his view on the Mexican law, because we know that there is possibilities of certain extensions in the US, in Europe, and other jurisdictions, but Mexico is a country that's very close to us, very friendly within the Latin American area, and a country that has many similarities with Brazil. So we thought it would be very useful for our association and for our attendants to have a view from Mexico. With that, I pass the word to Sergio. Please, Sergio.
Thank you, Luis Enrique. Thank you for the presentation, and thank you to ABPI and Luis Edgardo Montauri for the invitation to participate in this 41st International Congress. So as you will be able to see, because I believe you are going to show my presentation, I will be going through it, explaining it. That's correct. So well, before beginning with the presentation, let me congratulate Professor Tim and Justice Barroso for their excellent and very interesting presentations. Turning to the presentations, as you can see, I will be talking about patent term adjustments in Mexico. No? I think this topic might be of interest and important for you to know the Mexican experience in this sense, more particularly with respect to the STF decision that you were commenting about and the implications that it has had in Brazil. So first of all, it is important to mention that in Mexico, there has been not extensions per se. So adjustments or disadjustments have been granted under certain conditions, which I will mention in the following presentation. No? I should add that adjustment is the, let's say, the generic term that encompasses corrections, extensions, and also a complementary certificate that it is now included in our recent new law. No? This issue of patent term adjustments started with in Mexico back in the late 80s, more or less, when Mexico started with negotiations with the US and Canada with respect to the NAFTA treaty. You know? Let me, can you, yes. So our first experience in this sense, as I was mentioning, thanks to NAFTA, is the topic of the pipeline patents in Mexico. No? So NAFTA was the one that caused introductions of the pharmaceutical inventions, among others, such as chemical inventions, in the Mexico or the Mexican IP law of 1991. In the prior law, in the law of 76, that was not possible to file and obtain protection for pharmaceutical and chemical inventions. So again, thanks to NAFTA, they were included in the 1991 law. So this pipeline regime basically means the recovery of patent of pharmaceutical applications from the public domain. This was provided in a so-called 12th transitional article of the 1991 law. The conditions for getting pipeline pharmaceuticals were the following ones: there should be a corresponding patent application that needed to be filed within 12 months of the enactment of the law. The application should be filed by the first applicant of the corresponding foreign patent application or by the assignee. The applicant could prove to have or should prove to have filed the application in any other of the member countries of the PCT, or prove to have obtained the corresponding patent, and the exploitation of the invention or the import on the commercial scale of the patented product or of the product obtained by the patented process had not been initiated by any person in Mexico prior to filing of the application in Mexico. No? It is very important to mention that what the transitional the Article 12 mentioned precisely that the term of the patents granted under the provisions of this article will end in the same date as the patent granted in the country where the first application was filed. But the term will never exceed 20 years as of the filing date in Mexico. So patents were granted following the term granted in the country where the first application was filed. No? So we needed, or to obtain these corrections, or the correction was able to be obtained up to 20 years as of the Mexican filing there, when litigated, and that therefore were granted by federal courts. No? This is a timeline of examples of pipeline patents in the practice. So, let's say in a nutshell, the life term of the patent, of the pipeline patent, has to match the life term of the foreign patent on which said pipeline patent was based, including any extensions that said foreign patent benefited from. When the Mexican Patent and Trademark Office, which is called INPI, Mexican Institute of Industrial Property, did not correctly match the life term of the pipeline patent to that of the foreign patent, we successfully litigated so that the correct life term was applied to the pipeline patent. No. So as previously mentioned, the life term of the pipeline patent could not exceed, in any case, 20 years, excuse me, from the filing date in Mexico. And as you can see in this timeline, it was possible to obtain a maximum of 20 years from the filing date. In this particular case, there was only, I understand there was only one patent that obtained that 20 years from the filing date. But here, as you can see, sometimes INPI, there were not that many cases litigated. As I understand, there were around 600 pharmaceutical patents that were able to be to be converted to pipeline patents in Mexico, but only I think only 12 were litigated, and out of those 12, 6 were litigated by our firm successfully now. So as you can see, sometimes INPI consider a priority incorrectly because it was, let's say, a provisional US case that did not match the patentable subject matter of that of the Mexican pipeline patent. So we litigated that in order for the priority to be the correct one. So in this case, let's say the priority, sorry, I'm not showing the, there you can see the pipeline, sorry. So in this case, the priority, as you can see, that goes back to 1995, once that it was corrected through litigation, again, matching the patentable subject matter from that of the Mexican pipeline patent, was or had a life term fix of 20 years that ended in 2005, and the filing in Mexico was in 92. So there was 13 years of adjustment of the life term of the pipeline patent in Mexico. Okay, and the other example is the one referring that, and again, as I was telling you, there was only one case, a 20 years adjustment of the patent as of the filing date in Mexico. In this case, starting in 92 and ended in 2012. So this experiment was very interesting and was, as I was telling you, the first Mexican experience to adjust the life term of pharmaceutical and chemical patents. The second example or second case we have here is the recently Supreme Court decision that was decided only last year. Now, this court decision rationale is the following. Excuse me. The rationale established that in 1991, our law did not provide for maximum terms for the Mexican Patent Office for the issuance of official actions and decisions during the patent prosecution. Some rules for the maximum responses times for the procedures presented before INPI are provided in administrative decrees, which establish certain deadlines, but as being a decree and not being included in the law, does not follow with the principle of hierarchy of the law, no? But NAFTA provides that a life term of a patent could be of 70 years as of the granting day of a patent. So the decision resolved that it was suitable to compensate the life terms of the specific patent subject matter in that litigation, based again, and thank you to NAFTA and persuasive arguments based on these mentioned decrees that tend to unjustified or delays during patent prosecution up to 70 years upon granted, no? So this rationale, as I was mentioning, compensated the delay that was more than 5 years and 8 months, I think. And it gave them the 17 years of life patent term upon the granting term, no? What I may be able to say is that perhaps this resolution must have, or after making a personal reflection, this resolution could have been more based on certain equity, as in that time, which was last year, the project of the new law was already published, and it was well known and public that there was going to be the possibility to obtain a so-called supplementary certificate, no, for in case of delays from the Mexican Patent Office. So it's interesting to know this decision, and this decision, however, it was a divided decision by the justices, 3-2. So therefore, it does not constitute jurisprudence, and therefore is not binding to INPI to follow. So therefore, whoever is interested in enforcing this type of situation in the near future will have to take that into account now. However, as I am mentioning, there is at this time currently the possibility of obtaining a supplementary certificate under our new law that came into effect in November of last year. So this is the case of the supplementary certificate of life-term correction due to delays in the prosecution of a patent. In November 5, 2020, our new industrial property law entered into force, including this new scheme of patent term extension derived from the unjustified delays by INPI in prosecuting and granting patents. The main features of this so-called supplementary certificate is that the duration of it should not exceed 5 years, that the patent holder may request a supplementary certificate only once by filing a brief that must meet the requirements set forth in our law and its regulations. We still do not have regulations to the law yet. The application must be submitted independently when replying to the notice of allowance. And when the granting of the complementary certificate is authorized, the INPI will notify the applicants so that within a period of 1 month, the proof of payment of fees corresponding to the issuance of the certificate title is submitted. No? Let me comment briefly that our law considers as reasonable delays the following ones. The period that elapses between the date of receipt and the date of favorable resolution of the formal examination. The periods are attributable to actions or omissions of the applicant tending to delay the procedure for granting the patent and the extensions to answer deadlines. The periods not attributable to actions or omissions by INPI or that are beyond its control, excuse me, such as those that pass in the substantiation, I should say, of any means of administrative or jurisdictional challenge or that derive from them, and the periods attributable to force majeure or fortuitous events. No? Further, the delays that are not attributable to the applicant are those that will be considered as not reasonable and will be considered for the supplementary certificate. An example, for example, would be if INPI issues the first office action more than 5 years after the filing date in Mexico. It's not changing. Can you, I'm sorry, can you go ahead? No, it's one before. And the last one is the supplementary certificate of the lifetime of the correction due to due to regulatory delays. And however, this is provided in the new NAFTA agreement, and that means that these supplementary certificates will be available to justify delays that occur during regulatory approval for working the invention. No? However, it is not included in the domestic law, and there is a vacation legis of 4.5 years for the for the new NAFTA agreement to include the relevant provision. No. Well, that it's all in my presentation, and I trust, I don't know if the slides were correctly passed, but hopefully this helped to learn more or less the Mexican experience is these so-called patent adjustment terms in Mexico that perhaps will help to understand better the situation towards the STF decision recently held by the Brazilian Supreme Court Justice. Thank you very much.
Thank you very much. Thank you very much, Sergio, for the presentation. This gives a very interesting view of the Mexican law and what we could expect in the future in Brazil, hopefully with term adjustments as well. Como nós já estamos com bastante adiantado da hora e as sessões começam às 11.
Because we are rather late and the other sessions started at 11, I am closing this. Thank you, Luciano, once again, and Sergio for having devoted comments or having addressed comments to this session with such relevant aspects for discussing this matter. So thank you all, and we close this meeting. Thank you very much, Enrique. We'll follow with our presentations with panels 5 and 6 now, and at 11 o'clock. And we also have the table topics this afternoon and a networking session at 5:30, diversity and inclusion, learning and sharing successful experiences. Don't miss it out. Thank you very much. Já acabou aqui, Ana.